Okay. All right, you're up. You're muted. You need to unmute your mic. I do
Thank
that
you.
constantly.
May it please the court, Roland Waller, attorney for Bobby Joe Albritton. I'd like to reserve 5 minutes of my time for rebuttal or whatever
Sure.
time I use in my primary argument. Unfortunately, Mr. Albritton passed away during the pendency of these proceedings, and so we're proceeding as the personal representative of as the state. Mr. Albritton and Mr. Barnes owned a promissory note and mortgage of Jeff Marahan. Mr. Marahan defaulted in his payments under the promissory note and mortgage in 2008. Mr. Barnes filed a mortgage foreclosure action to foreclose on the promissory note and mortgage. He named Mr. Albritton as a defendant in those proceedings. The final judgment of foreclosure was not entered until November 25th, 2015. The final judgment was for the total amount that was owed under the promissory note. The property was sold at judicial sale, and Mr. Barnes was a successful purchaser of the property in the judicial sale and received a certificate of title in 2016, an amended certificate of title. I did not represent Mr. Albritton in the underlying foreclosure action. After Mr. Barnes received title to the property, Mr. Albritton came to see me, and we filed this foreclosure action to foreclose Mr. Albritton's interest in the promissory note and mortgage and judgment of foreclosure. There is very few cases, if any. Well, there's one, which is a 1942 case of Kine versus Manley, which sets forth how you go about foreclosing.
If I understand Kine correctly, which is fairly skimpy on the facts of the case, but it seemed to me that the issue there had to do with co-tenants in the property, correct?
No, sir. That's not.
As I read it, as I understood the fact scenario, and I'll go back and read it again if you disagree, is that co-tenants in property, one of the co-tenants acquired the mortgage on the property. And the question was that the Supreme Court was addressing was, what was the effect of the merger of the legal and equitable interests in that co-tenant? And they said that those interests merged as to the co-tenant, but the co-tenant could still foreclose the mortgage on the other co-tenant. Is that,
Your Honor,
within our scenario here?
If that is, I've read Manley and any number of times, and so certainly if that's the court, my understanding is that under Manley they own a joint note and mortgage, and in fact, if you read through the Manley decision, it talks about that, about whenever one goes through and be able to foreclose their interest. But that's just my understanding. So if Manley, it does not stand for that proposition, I think that it does. But in any event, I would proceed to say that a co-owner of a promissory note is entitled to foreclose his interest in the property. And we set forth that we are the co-owner, we have a half interest, and our interest is not foreclosed as a result of the foreclosure action, even if we're joined. And I think the case law is fairly,
Mr. Waller, perhaps I could ask a question. This case came before the trial court on a motion to dismiss. Is that correct?
Yes, Your Honor.
There was no evidence introduced at that hearing. Is that correct?
That's correct, Your Honor.
All right. And one of the defenses here that the trial court relied upon is res judicata. That's correct, right?
Yes, Your Honor.
And if there's no evidence, there's no judicial notice, why isn't this case governed by this court's opinion in THEWS, T-H-E-W-S, which came out in 2017?
Your Honor, I don't know.
That's okay. I know because I wrote it.
Well, I'm not.
That's why none of us know that case.
You do. You signed on to it, Judge Northcutt.
Even so.
And it talks about the pleading stage that res judicata is normally an affirmative defense and it requires proof. And if you can't establish it from the cover of the pleadings, it's inappropriate. I look at the final judgment on this case, and there's no mention in the final judgment, which was an attachment, what defendants remained, what interest. So I believe, or at least I'm concerned, that we have a case that says in THEWS, which by the way is at 210-7-3, that suggests that the trial court erred, that this issue has to be resolved further down the highway. And that's why I want to find out if I'm wrong or not. My interpretation of my case doesn't make it right.
Well, Your Honor, I've certainly understood, and I argued to the trial court that it was it should be an affirmative defense pursuant to the rules, and I believe that was in fact.
The opinion says affirmative defenses such as res judicata must be typically raised in an answer, not in a motion to dismiss, unless the allegations of the complaint demonstrate that the action is barred by res judicata. And there's a number of elements to res judicata, and I'm not sure you can find them in the attachments.
Well, I'm with you.
You like my research? Okay, thank you.
I'm going to be quiet. I'm going to sit down, and I'm my argument. You just made my argument as far as that's concerned. So I at this point, I need to be, understand.
Don't rely on me to your detriment. Make your argument as well.
Well, Your Honor, the complaint, basically says, that we have a half interest, and you can't foreclose out a superior interest, and I would also argue that you can't foreclose out a lien that is co-equal to yours, because you can only foreclose out junior encumbrances. And there is the Bank of America versus Kipps Colony, which talks about a final judgment of foreclosure being ineffective against a superior.
But let me say this, your share of the mortgage lien is
That's correct.
One mortgage, one lien for one debt, correct?
That's correct.
So it's not superior. Correct. You would at most co-equal.
They're co-equal. That's correct. And the case is
co-equal interest in a mortgage, and you haven't contended that both of you had to file a mortgage foreclosure to foreclose on the mortgage. One of you filed a foreclosure of the mortgage because there had been a default in payment of the note, not two mortgages, not two liens, not two notes. Correct.
That's correct, Your Honor. I didn't get your audio.
I see a fairly significant difference between that and the case law that says the court can't foreclose a superior lien that is other than the lien that is being foreclosed upon. That seems to be a fairly significant difference to me.
Well, I believe the case further say in another way that you can only foreclose out a junior interest. And certainly
it's not a junior interest, a junior lien. And in this case, there was only one lien. There weren't two.
Well, I submit, Your Honor, you're correct. And we have a half interest in that, in that lien. So how can how can Mr. Barnes foreclose out my, that's the crux of the case.
That's a good question, but the remedy might not be another foreclosure action,
But
because the lien went away when it got foreclosed, correct?
it went away as far as a half interest or Mr. Barnes's interest in the property.
But what is the debtor supposed to do in that situation? His
pardon?
property gets taken. What is the debtor supposed to do when the property gets taken to satisfy the debt? And now there's another lienee out there, lienor, I guess, who says, wait a minute, now I get to foreclose on the property.
Well, I believe that I have a action as far as the, he's only entitled to half of what the amount of the mortgage was too, of the promissory note.
You're talking about Mr. Barnes?
Mr. Barnes was only entitled 1/2 of what was owed under the promissory note.
So there you go. That might be the key to this case. It's not a matter of the lien, it's a matter of the debt. And who is entitled to the proceeds of the debt, of the foreclosure.
Well, Your Honor, that is, I submit that, again, I guess your reading of Manley, Kind versus Manley is exactly what, where you and I don't agree. And of course, you're the one that you get to make the decision. It's in my opinion, but I would also
my two buddies here get to
well,
help
I
me with that.
I understand, but I also filed a declaratory judgment action. And so to try and, okay, well, if I'm not entitled to foreclose, just what are my rights? I should not just have to proceed against Mr. Barnes because, he's taken away my collateral. So how can he take away my interest in the lien? I have just as much right to that collateral as he does. And so therefore, it's unusual. And so, I guess the trial court needs to sort that out, but I certainly should be able to at least pursue a remedy, a declaratory judgment action. Well, what rights does Mr. Albritton have? Does he have a lien against the property, and can we foreclose it? Can we foreclose a half interest? Am I reading Manley differently? But certainly you can't say that Mr. Albritton doesn't have any rights whatsoever, and Mr. Barnes is entitled to a judgment for the full amount of a note that he doesn't own the whole amount for, and further be able to take all the collateral and wind up with the property. I think that's key to it also, is who wound up with
he bid at a foreclosure sale.
That's correct, but
what if it had been a third party who bought it at the foreclosure sale? Where would the party stand? What if a third party had succeeded in acquiring the property at the foreclosure sale? Where would the party stand then?
Well, I will be glad to give you my opinion, but that's not what we have here. But my opinion is they only got a half interest. It's subject to the half interest of my client in that.
It was satisfied.
But the lien was satisfied by virtue of the proceeds of sale and the judgment.
Well, it satisfied the plaintiff's interest in it. It didn't satisfy my client's interest. He brought this action as far as his interest in the note and mortgage. He didn't bring it in behalf of my client's interest. And I think it's fairly apparent that my client has a half interest in the property.
Your client was named as a defendant in that.
Note and mortgage.
Your client was named as a defendant in that suit.
So the subsequent, I'm sorry, were you just question of the
Mr. Waller, your client was named as a defendant in Albritton's foreclosure action.
Yes, he was.
And there was a judgment.
Barnes is right, correct.
And did your client appeal? Did your client move to set it aside? What happened? Or we don't know. We don't have that in our record, correct?
That's correct, Your Honor. What you have is the complaint that says that my client still has a half interest in the mortgage, and that we're still have a half interest in the amounts owed under it. And Mr. Barnes has now wound up taking all the money and all the collateral. And so my position is that we're entitled to proceed against the collateral because we still have, as far as that's concerned.
You are at your 5-minute left mark, Mr. Waller, so use them as you wish.
Well, I'm happy to continue to debate the matter, but I'll wait and I'm rest at this time.
Okay. Well,
Thank you. May it please the court, Matthew Wolf from Ivanhoff and Wolf on behalf of the appellee Joseph Barnes. Today we're going to ask the court to affirm the lower court's ruling of dismissal with prejudice. I want to focus my time on two areas. First, I want to talk about the idea of res judicata, and then I briefly want to talk about the 3 cases cited in the appellant's brief, as I believe they're inapplicable or actually beneficial to my client. So the court knows the complaint alleges there was a prior foreclosure, which I'll refer to for the ease as the Barnes foreclosure. It was alleged in the complaint. It was actually an allegation, and it's not disputed by any party, Mr. Albritton, that his client was named in that complaint. Attached to the complaint, this was the second amended complaint, was a consent judgment, and the consent judgment clearly states in paragraph 5 that all the defendant's interests are foreclosed and wiped out, which would include Mr. Albritton's interest. So when we went before the trial court on the motion to dismiss, the issue was really res judicata. And if you review the transcript, this was the issue that the trial court judge had. How are you bringing this separate case when this has already been resolved? And all you have to do is look within the 4 corners of the complaint. You have a consent judgment that wipes out Mr. Albritton's interest. You have allegations in the complaint that confirm he was named in that judgment.
Is there anything in the pleadings that was before the trial court that said he remained a defendant until the time of the entry of the final judgment?
Not within the second amended
That's
complaint.
an evidentiary matter, and a motion for dismiss is limited to the 4 corners of the pleading document. And that's my concern. There's nothing that tells me that he was there at the final. His name is not mentioned on that page of the final judgment. In fact, it's a form final judgment, it has defendant, then has a parentheses S, close parentheses. It doesn't list who was foreclosed out. It tells me, as I read it, absolutely nothing, which means that you need an evidentiary record to prove up your res judicata. I'm not saying you can't or you won't. My concern is at this stage of the pleadings, whether it was appropriate.
And I understand the concern. I think it's a valid concern, but Mr. Albritton is named in the case style. And typically when you dismiss a defendant or a defendant's removed, you'll remove them from that case style as well. And he still remains. And even during the hearing, if you read the transcript, this wasn't disputed. It hasn't been disputed at any point in time. So what we're essentially asking the trial court to do is put on a blindfold when Mr. Albritton agrees that his client was included within this judgment, that his client's named in the case style, and then proceed forward, which I don't think would be proper. He's made the statements at the trial court level. He's made the statements in his brief, and the consent judgment clearly has him listed as a defendant. And so when we look at the 2 cases, and this is what the trial court judge had an issue with, when you look at the 2 cases in the Barnes foreclosure, the 2009 foreclosure suit that he filed, it is the same exact note, the same exact mortgage, the same exact property, the same exact parties, and the same exact cause of action. The issue that Albritton has is his ship has sailed. If he wanted to protect his interests and defend his interests, he should have done so in the Barnes foreclosure. Apparently, based upon the consent judgment, which was included in the complaint, he did not. And all of his interest was wiped out. This is not in dispute. So we believe the order of dismissal was proper. We believe that the complaint was facially deficient. And the case law is clear. If you have attachment to a complaint and the allegations of the complaint are contradicted by the attachment will control. And this attachment attached to the second amended complaint states that his interests were wiped out, in our opinion.
So
Okay,
that, is
typically
that,
under the caption of this case, where it says consent uniform final judgment of foreclosure. From that point, going to the top place where the judge signs, identify for me where the defendant's name appears.
I'm sorry, in the case style you're asking?
You have a consent uniform final judgment of foreclosure. That is the pleading that was attached. The judgment that was signed by the trial judge would be from that language to the trial judge's signature. So when I look through there, I don't see his name. Can you tell me if I missed it?
You have not missed it. Our claim is
How
that
does anybody reading that document know with precision what was adjudicated? Whether somebody was voluntarily dismissed, whether someone had some sort of, I'm not going to go Mary Carr, but that they were there at the time of the final judgment. That's the difficulty I see with pleadings. If you can't tell me that they were there, how can the trial judge make that determination without evidence?
I understand that concern, and I would simply rely upon the case style. He's named. And even at the hearing, if you read the transcript, this wasn't disputed.
let's say that the face of the complaint and its attachments don't establish res judicata because there's no identity of the parties, because as Judge Castellano said, you can't eliminate the possibility that he was not there at the time of the final judgment. Is there an alternative basis to support the motion to dismiss based on the allegations of the complaint and the attachments? Meaning the lien was satisfied. Is that a ground for to support a motion to dismiss for failure to state a claim for foreclosure?
And I believe it would be, and I believe that the concerns Judge Northcutt raised is proper. I think everybody agrees this was a relatively odd situation where two parties are listed on a note mortgage as what I'll call co-lenders. My opponent calls it co-equal liens. But as Judge Northcutt discussed, there was only one lien. There was one mortgage that was foreclosed. And this is not in dispute. This is what the consent judgment.
Then the question becomes, Mr. Wolf, what is the remedy for a person who is owed half the sums under the note?
Yeah, so
The mortgage basically has now disappeared because the lien is gone. Under my, hypothetical or my theory. What is the remedy for the person who is owed half the proceeds of the note and has not received them?
So it really goes back to the instrument that we're looking at, the note mortgage. If the parties were co-lenders, each of the parties put forth one half of the funds lent, it might be a breach of contract claim. I don't know what the agreement was between the appellant and the appellee. But what I do know.
You have on the face of the note, I think that it says that they are co-tenants in the note.
It says they have an undivided one half interest. Joseph Barnes and Bobby Albritton, each of us to an undivided one half interest. So that's why I refer to them as co-lenders. I think the idea of referring to them as co-equal liens is improper. And there's a case that was cited by Mr. Waller that deals with co-equal liens. And that was the Avignon case. And in the Avignon case, you had actually two separate parties with two separate interests and two separate liens. That's how you get to a co-equal lien status. Here we have one mortgage, the same mortgage that was foreclosed and admitted in the complaint in the Barnes foreclosure is the same mortgage that Mr. Waller is attempting to foreclose. That mortgage is extinguished. We know from longstanding case law, once a judgment is entered, that mortgage then merges with the judgment. He has no instrument to foreclose on. So if we look at them as co-lenders, instead of what Mr. Waller refers to as tenants in common to the note mortgage, then that is res judicata as well because it's already been decided. So if the court doesn't have any other questions.
The Avignon case, though, isn't really a question. It's not really a question of the rules of priority. It really has to do with statutory interpretation of the priority of those specific types of liens, right? The tax collectors lien and so forth and so on. But I'll tell you, I found a case that involved actual co-equal lenders' liens. And, you know, neither of you have cited it. It's an old case, I think, out of the 4th or 5th DCA. And frankly, what it says is the remedy of the co-lienor basically is, you know, to have a share in the proceeds. But it doesn't, that lien doesn't survive. That would be, and I'll tell you what it is, McCory versus Beneficial Savings Bank, 537 second 981. Co-mortgagees were entitled, says the co-mortgagees were entitled to share pro rata in the proceeds of the foreclosure. That is not another foreclosure action.
And I agree. I agree, because you cannot foreclose something, an instrument.
But it doesn't leave the co-mortgagee without any remedy.
I would agree as well, but the remedy here is incorrect. The cause of action alleged in the complaint is improper because he cannot foreclose on that note mortgage. He
Has
could
he
have brought
alleged a proper action for a declaratory judgment about what his rights are?
Well, the declaratory judgment is about superiority. And I think that's improper because you can't have superiority. The appellant agrees, the appellant's argument is that they're co-equal liens. So bringing a deck action to determine whether or not you're superior, I think is simply inherently wrong, based upon their own argument that they're co-equal liens. So I think the deck action would be inappropriate here as well, based upon the fact that the mortgage was foreclosed. And now this was the 3rd complaint filed with identical fact pattern in each and every one. He hasn't changed his theory. He did add the deck action in account on the first amended complaint, but he hasn't changed his theory. The theory the entire time is he still has a co-equal lien that he wants to foreclose. I don't think it doesn't pass the smell test because that lien is already foreclosed. And the nice thing that the Avignon case actually did is it gave, in my opinion, really a pathway for parties who may have co-equal liens on what to be done. It says that what the HOA, the villages, should have done is if they had a co-equal lien with the county, they should have named the county in their foreclosure. And that would have resolved the issue. They didn't. So then the county had to go back and file a deck action to figure out what they were to do. That's not our case here. And we believe Albritton was named in the foreclosure, and Barness has actually followed the path that was outlined for us in the Avignon case. So if the court doesn't have any other questions on that, I do want to touch on Kind versus Manley really quick. Kind versus Manley was relied upon in the second amended complaint, the brief, the initial brief, and the reply brief. Judge Northcutt, I agree with your assessment of the case. That case doesn't stand for the proposition that we're here for today. That case stands for if you have two parties who are tenants in common, and there is a mortgage that encumbers, pardon?
Tenants in common in the property.
Correct. Tenants in common in the property, and that mortgage encompasses the entire property. If one tenant in common chooses to buy that mortgage, he can then foreclose the remaining tenant in common of the property. That's all that case.
Even though as to his own co-tenancy, the interests have merged.
Correct.
Right.
And so I don't think Kind versus Manley gets him there. I think it's a completely different case with a completely different opinion. It's inapplicable as to what we stand for here today. I do want to make one note of the Bank of America versus Kipps case. Now, the Bank of America versus Kipps case, I don't believe is applicable because we deal with junior and senior interest, which is not the claim by the appellant. But the important thing what happened in the Bank of America versus Kipps case is Bank of America didn't file a separate suit to foreclose its lien. Bank of America went back to the homeowners association case and sought vacation of that judgment under 1.540. And that was our argument at the trial court. You should not have filed a separate action. If you're concerned about your interest, you should have filed something in the Barness appeal. I'm sorry, the Barness foreclosure.
You have just sued your client for half of the proceeds?
Or he could, depending on whatever the co-lender agreement was. But the co-lender agreement, I still don't think creates a co-equal lien.
We're assuming there was a separate agreement aside from what's reflected on the face of the note.
Yeah, I don't think anybody can tell what the agreement between the co-lenders was.
So assume that the face of the note just accurately reflects the arrangement, that they are 50-50 owners of this note. Your client forecloses the mortgage, basically satisfies the obligation of the property owner by, bidding the amount owed at the sale and buying the property. Would Mr. Waller's client then have a cause of action against your client to collect his half interest in those proceeds?
I believe so if you rely solely upon the language of the note mortgage. He would have some type of recourse. I agree with that.
He's not left just out in the dark, out in the cold universe. He has some legal ability to recover what he's owed.
Well, to an extent. I mean, to an extent of what took place in the Barnes foreclosure. Now, if you agree with what I'm saying and what the appellants agree with as well, Albritton was included in that Barnes foreclosure, which wipes out all of his interests. So if you agree with me that he was
wiped out his lien, but it doesn't wipe out the debt.
Correct. So based upon res judicata, we believe the trial court's opinion was proper. It is undisputed that Albritton was named in the Barnes foreclosure. It is undisputed that judgment was entered in that case. It is undisputed that the same note mortgage they're attempting to foreclose here for the third complaint. For that reason, we ask the court to uphold the order of dismissal. Thank you.
Thank you, Mr. Wolf. Okay, Mr. Waller, you've got 5 minutes.
Thank you. I do not believe that you can take away my client's collateral, or Mr. Barnes was not able to take away the collateral that my client has in the mortgage. His foreclosure action, he can't foreclose any more than what he owns, and he can't foreclose out anything but junior liens. And
Now,
so
we don't know from the record whether your client defended on that basis or any basis, correct?
that's correct. We don't know. And so that's why, I believe that the case needs to be sent back to the reverse and sent back to the trial court. And then if they wish to assert an affirmative defense or res judicata or whatever, I think that we're then going to have to go back and see what happened in the underlying foreclosure action to see whether or not what interest, if any, of my client was foreclosed.
What we do know from the face of the complaint, the attachments, is that the lien is satisfied, that the property's been foreclosed on.
We know that Mr. Barnes's interest in the mortgage was foreclosed.
Well, Mr. Waller, do you have any authority that suggests that the co-owners of a note and mortgage can just foreclose part of the lien and sell the whole property and take the proceeds and divest the property owner of any further interest in the property?
And then sue and foreclose again on the property.
Was foreclosed and disappeared, correct?
Do I have any authority? No, Your Honor, because you already pointed out that my reading of Manley is not correct as far as them being co-owners of a mortgage. And so you found a case which I didn't see, and so no, therefore I go by, if you don't hold an interest in a half interest in the real property, you cannot a lien, you cannot foreclose any more than what you have. And Mr. Barnes only had a half interest in the mortgage. And so
Well, let me ask you this then.
foreclose more
How
than
would the acceleration happen under this note and mortgage included acceleration clauses? So if the debtor defaults, can just one party accelerate half of the obligation? I mean, how does that work?
Well, I think that he can accelerate the full amount of the note because as far as the borrower is concerned, he defaulted. And however,
It's a one
that doesn't
obligation.
he defaulted on the note.
Right.
That does not give right because he cannot take advantage of he can foreclose his half interest in that obligation and in the lien that he has. If he doesn't have the full, he can't foreclose the full lien against the property if he doesn't own it.
Now, if you were representing a third party buyer who had bought it at the foreclosure sale, how would you defend against this subsequent foreclosure action? Or would you tell your client, they got us dead to rights, they get to foreclose on the property again?
Well, I believe that if I was going to represent, number one, if it was a third party bidder, I think that, this complicates matters substantially. However, we didn't have a third party bidder, and Mr. Barnes is the one that wound up with the property and the collateral. And so
Mr. Barnes is not the current owner of the property, correct? He then transferred it.
yeah, well, I know we filed a notice of lis pendus, and before he transferred it, and so whoever he transferred it to was on notice. Unfortunately,
How about the debtor, property owner? Are you saying that only, that the only part of his interest that was foreclosed was the half interest in the accelerated debt?
yes, sir. That's exactly what I'm
So
saying.
is he still, by all rights, still an owner of the property?
He still has a depending on if the yes, well, no, what it is whoever buys the property is subject to the half interest that Mr. Albritton still owns. So whenever you were a third party bidder, then you take it subject to the half owner's mortgage interest in the property, because only half of the mortgage was foreclosed. The other half remains outstanding.
But all the debt has been satisfied, right? So the borrower's off the hook.
It shouldn't have been. Well, but we have a final judgment, and so he put the full amount down, and as a result of Mr. Barnes bidding that in, the debt has been established. There isn't any deficiency, but we still have a lien against the property for our interest, our one half of whatever was owed. So our collateral goes away. So the interpretation.
But your collateral means nothing unless there's an underlying debt. You only have collateral for a debt. So you're suggesting that half of that note is still owed to your client by the borrower.
Correct.
Even though it was the whole note was satisfied with the proceeds?
Well, my client didn't get any of it. Yes, I am. Absolutely. How did my client didn't get anything out of this?
But the borrower paid up. The borrower said, you know what, take the house.
Lost the house altogether.
Well, I don't disagree that the borrower is out. So that leaves us with, okay, whoever purchased it, in this case, Mr. Barnes, took it subject to my client's half interest in the amount of in the lien that we have.
If there's no underlying debt, there can be no lien. The debt went away, so there's no collateral for a debt that is owed.
I don't disagree with that statement, But then you are basically saying that because you and I own that, you can just go ahead and you can take all the money from the debt and
Well, I
you
didn't
can
say
take
that.
No, I think what the focus is on remedy. I think the focus that's being driven at is what is the remedy? And the remedy may be conversion, theft, resulting trust, and some sort of equitable, but I think that's what, you know, not only speak for Judge Northcutt, he's much superior to me, but I think that's what the thrust is. What is your remedy that's now available if the lien on the property has been foreclosed? They paid the money, as Judge Atkinson pointed out. Somebody took the corpus of those funds. Now, I don't know if that's theft, conversion, civil theft, you know, resulting trust, but what we're looking at is the remedy to make your client whole.
I couldn't agree more with you. And unfortunately, I didn't have any guidance, and I'm evidently misread Manley. And I thought I knew what to do, but that's the reason why I filed a declaratory judgment action to say, okay, help, you know, determine what the rights of the parties are in conjunction with this. Do I have a right to do this? And the judge says, no, you know, it's res judicata, you're out of here. And so I believe that I would ask the court reverse and send it back and let my client have its day in court as far as what are our remedies.
Okay.